Hi guys, welcome back to my channel. So today in this video I would like to continue my previous video entitled What are the Hague Visby rules? A state which is not a member of the International Monetary Fund and whose law does not permit the applications of the provisions of the preceding sentence may, at the time of ratifications of the Protocol of 1979 or accessions thereto, or at any time thereafter, declare that the limits of liability provided for in these conventions to be applied in its territory shall be fixed as follows. 1. In respect of the amount of 666.67 units of account mentioned in subparagraph A of paragraph 5 in this article, 10,000 monetary units. 2. In respect of the amount of 2 units of account mentioned in subparagraph A of paragraph 5 of this article, 30 monetary units. The monetary units referred to in preceding sentence corresponds to 65.5 milligrams of gold of small fineness 900. The conversions of the amount specified in that sentence into the national currency shall be made in according to the law of the state concerned. The calculation and the state and the convention mentioned in the preceding sentence shall be made in such a manner as to express in the national currency of that states as far as possible the same real value of the amount in subparagraph A of paragraph 5 of this article as is expressed there is a units of account. States shall communicate to the depositary the manner of calculation of the result of the conventions as the case may be when depositing an instrument of ratifications of the Protocol of 1979 or of accessions thereto, and wherever there is a change in either. Neither the carrier nor the ship shall be entitled to the benefit of the limitations of liability provided for in this paragraph if it is provided that the damage resulted from an act or omissions of the carrier done with intent to cause damage or recklessly and with knowledge that damage will probably result. F. The declaration mentioned in subparagraph A of this article, if embodied in the bill of lading, shall be prima facie evidence but shall not be binding or conclusive on the carrier. G. By agreement between the carrier, master, or agent of the carrier and the shipper are the maximum amounts that those mentioned in subparagraph A of this paragraph may be fixed, provided that no maximum amount so fixed shall be less than the appropriate maximum mentioned in that subparagraph. H. Neither the carrier nor the ship shall be responsible in any event for loss or damage to or in connections with good if the nature of the value thereof has been knowingly misstated by the shipper in the bill of lading. 6. Goods of inflammable, explosive, or of dangerous nature to shipment whereof the carrier, master, or agent of the carrier has not consented with knowledge of their nature and character, may at any time before discharge be landed at any place of destroy or render in no cause by the carrier without compensation, and the shipper of such goods shall be liable for all damages and expenses directly or indirectly arising out of, resulting from such shipment. If any such good ship with such knowledge and consent shall become a danger to the ship or cargo, they may in like manner be landed at any place or destroy or render in no cause by the carrier without liability on the part of the carrier except to general average. Article 4 Peace applications of defenses and limits of liability. 1. The defenses and limits of liability provided for in these rules shall apply in any actions against the carrier in respect of loss or damage to goods covered by a contract of carriage, whether the actions be founded in contract or in tort. If such an action is brought against a servant or agent of the carrier, such servant or agent not being an independent contractor, such servant or agent shall be entitled to avail himself of the defenses and limits of liability which the carrier is entitled to invoke under these rules. 3. The aggregate of the amount recoverable from the carrier and such servant and the agent shall in no case exceed the limit provided for in these rules. 4. Nevertheless, a servant or agent of the carrier shall not be entitled to avail himself of the provisions of this article if it is not proof that the damage resulted from an act or omissions of the servant or agent done with intent to cause damage or recklessly and with knowledge that damage would probably result. Article 5. Surrender of right and immunities and increase of responsibilities and liabilities. A carrier shall be at liberty to surrender in whole or in life or in part all or any of his right and immunities, or to increase any of these responsibilities and liabilities under the rules contained if any of this article, provided such surrender or increase shall be embedded in the bill of lading issued to the shipper. The provisions of this rule shall not be applicable to charter parties, but if bill of lading are issued in the case of ship under a charter party, they shall comply with the term of these rules. Nothing in this rule shall be held to prevent the insertions in the bill of lading of any lawful provisions regarding general average. Article 6. Special condition. Notwithstanding the provisions of the preceding article, a carrier, master or agent of the carrier and the shipper shall be in regard to any particular goods be at liberty to enter into any agreement in any terms as to the responsibility and liability of the carrier for such goods, and so the rights and immunities of the carrier in respect of such goods, of his obligations as to seaworthiness. So far as this stipulation is not contrary to the public policy of the care of negligence of a servant or agent in regard to the loading, handling, stowage, carriage, custody, care and discharge of the goods carried by water. Provided that in case no bill of lading has been or shall be issued, and that the terms agreed shall be embedded in a receipt with which shall be a non-negotiable document and shall be marked as such. Any agreement so entered into shall have full legal effect. Provided that this article shall not apply to ordinary commercial shipment made in the ordinary course of trade, but made to other shipment where the character or conditions of the property to be carried out the circumstances, terms and conditions under which the carriage is to be performed as such as reasonably to justify a special agreement. Article 7. Limitations on the application of the rules. Nothing herein contained shall prevent a carrier of a shipper from entering into any agreement, stipulation, condition, reservations or exemptions as to the responsibility and liability of the carrier or the ship. Article 8. Limitation of liability. The provisions of these rules shall not affect and right and obligations of the carrier under any stages of the time being in force relating to the limitations of the liability of owners of vessels. Article 9. Liability for nuclear damage. This rule shall not affect the provisions of any international conventions or national law governing liability for nuclear damage. Article 10. Application. So, That's all the article. Don't forget to watch my previous video, and also don't forget to like, comment, and subscribe. Bye!